Welcome back to the deep dive. Today, we're taking a shortcut to being incredibly well-informed on a topic that sits really at the very heart of cybersecurity: investigations and ethics.
Absolutely.
Whether you're a seasoned pro, maybe prepping for a certification like the Certified Information Systems Security Professional, or maybe you're just intensely curious about what happens when those digital lines get crossed, well, you are absolutely in the right place.
hmm
We've got a stack of fascinating source material, specifically Chapter 19 of a CISSP study guide, and we are ready to, unravel it all.
Indeed. And this isn't just about the technical know-how, is it? It's not just securing systems. It's
Right.
really about the principles, the processes that ensure justice and maintain trust in our increasingly digital world.
Yeah, trust is huge.
Understanding how to conduct proper investigations and adhering to strong ethical frameworks. These aren't just good practices. They are absolutely fundamental for any security professional. Today, we're really going to try and connect the dots between, technical incidents and their broader legal and moral implications. Help you understand the whole landscape.
I love that, connecting the dots. It sounds like we're not just learning definitions, but really figuring out the why behind what we do,
Exactly.
the context.
Okay, let's unpack this. Our mission in this deep dive is to extract the most important insights, those actionable nuggets from this chapter. We want to give you a crystal clear understanding of how investigations work, what makes evidence actually stand up in court, and the ethical bedrock that truly defines our profession. Let's dive in.
Let's do it.
Understanding investigations, Domain 7.0, security operations.
So before we get into the nitty-gritty, the tools and techniques, what's the big picture here? Why are investigations such a core part of a security professional's role? Is it just about fixing problems, or is there, more at stake?
Well, inevitably, I think every information security professional will, at some point, encounter an incident that absolutely demands an investigation.
Right. It's bound to happen. It is. Think of it like detective work, but purely in the digital realm. The core purpose is always to determine what happened, how it happened, and, if possible, who was involved.
Okay.
Now, these investigations can truly range in formality. You might have very informal troubleshooting sessions. Maybe you're just trying to figure out why a server is running slow.
Yeah, the everyday stuff.
All the way up to rigorous forensic examinations designed specifically for legal proceedings. And the key thing here is that the rigor, the standards of evidence required, they vary widely depending on the type of investigation.
That really highlights the spectrum, doesn't it? From simple problem solving right up to high-stakes legal battles. So what's the biggest pitfall then? If you don't follow proper procedures, what's the ultimate consequence?
That's the crucial insight right there. The biggest pitfall, the ultimate consequence.
Yeah.
It's that a failure to follow proper procedures can have really severe repercussions.
Okay, like what?
Well, it can violate individual rights, which is a huge concern, obviously.
Huge.
It can lead to failed prosecutions in court because the evidence was mishandled, thrown out.
Wow.
And perhaps most critically for the investigator themselves, it can even result in legal action being taken against the investigator.
Ouch.
So it's not just about finding the bad guy or fixing the issue, it's about doing it the right way, with meticulous adherence to established legal and ethical frameworks.
Got it.
Imagine like a complex machine breaking down. An investigation is like taking it apart, inspecting every single component, and meticulously reconstructing the sequence of events that led to the malfunction.
Right.
But in cybersecurity, that machine also has these crucial legal and ethical components. They dictate exactly how you handle every piece of data, every interaction. If you neglect them, you can completely invalidate your findings, no matter how accurate they might seem initially. 2, types of investigations.
Oh,
Knowing the stakes.
that makes perfect sense. It sounds like there are different rule books, really, depending on the situation.
Yeah.
So what are these various investigation types? How do they differ in terms of formality, impact? I imagine you don't use a full-blown criminal investigation process for, say, just a slow server.
Excellent question. You've hit on the core principle there. The source material outlines several distinct types of investigations, and each one has its own purpose, its own scope, and crucially specific standards of evidence.
Okay.
This truly raises an important question right at the very outset of any incident. What is the primary goal of this specific investigation? Answering that question dictates the entire approach. How you collect evidence, who you involve, everything. 2.1, administrative investigations. So first up, we have administrative investigations. Think of these as internal affairs. They're focused on operational issues or violations of an organization's internal policies.
Okay.
They might support, say, human resources, disciplinary procedures, or maybe delve into technical troubleshooting that doesn't necessarily involve external legal action.
Right.
For instance, imagine an employee who is consistently accessing unauthorized files, or maybe engaging in behavior that violates the company's acceptable use policy.
It happens all the time.
An administrative investigation would focus on determining whether company policy was violated and, what disciplinary action is appropriate. The goal here is usually internal enforcement of rules, not necessarily criminal prosecution.
So like a company's internal audit
Mm-hmm.
or HR looking into a complaint.
Exactly, like an internal audit or an HR manager looking into a complaint about workplace conduct. The primary goal is enforcing internal rules. Now, it's also important to note, an administrative investigation can very quickly escalate.
Oh, so?
Well, it can quickly turn into a criminal one if, for example, what initially looked like a simple performance issue turns out to be, say, a system intrusion or theft of intellectual property. It happens more often than you might think. 2.2, operational investigations. Closely related are operational investigations. These are actually a subset of administrative investigations. They're specifically focused on an organization's computing infrastructure, purely to resolve immediate operational issues. They tend to have the loosest standards for information collection.
Why is that?
Because their primary goal is rapid problem resolution, getting systems back online quickly. Think of an IT team noticing really sluggish web server performance.
Yeah.
An operational investigation would trace the cause. Is it a faulty server, a simple misconfiguration, or maybe something more serious like a denial of service attack? The main goal is getting systems back online and identifying the root cause to prevent it from happening again.
Ah, root cause analysis.
Exactly.
Yes.
Evidence collection isn't as strict because it's usually for internal purposes only. It's very much like a car mechanic diagnosing an engine problem.
Right.
Their goal is to fix the car, understand why it happened, not prepare a legal case against the engine's manufacturer.
So this is more about fixing a problem and learning from it rather than punishment. It's really about the health of the system.
Precisely. The emphasis here is entirely on that root cause analysis, finding the fundamental reason an issue occurred. This often highlights areas for immediate fixes and, long-term improvements to prevent similar incidents. It's all about system resilience. 2.3, criminal investigations. Okay, moving up the ladder of formality now. We have criminal investigations. These are the big ones.
Right. Law enforcement involved.
Conducted by law enforcement, yes. They investigate alleged violations of criminal law. Their explicit aim is to charge a crime and prosecute the responsible party in criminal court.
Okay.
These investigations demand the absolute highest burden of proof, beyond a reasonable doubt.
That sounds very high.
It's a very stringent standard. It means law enforcement must demonstrate the defendant committed the crime by presenting facts from which there are no other logical conclusions. Because of this, they need extremely strict evidence collection and preservation processes.
Okay, Seth.
So if a cyber attack involves, say, fraud or theft or hacking that constitutes a crime, law enforcement steps in. Think police, the FBI, Federal Bureau of Investigation.
Right.
This is like a murder investigation, really. Every single piece of evidence must be meticulously collected, handled, documented to stand up in court without a shadow of a doubt. 2.4, civil investigations. Now, in contrast to criminal cases, we have civil investigations. These usually involve internal employees or maybe external consultants preparing a case for civil court.
Okay, civil court. Different purpose.
Different purpose entirely. The goal here is to resolve disputes between two parties, often corporations or individuals. They use a different standard of proof, too, called the preponderance of the evidence.
Preponderance of the evidence. How does that compare?
It's a weaker standard than beyond a reasonable doubt. It means the evidence must simply demonstrate that the outcome of the case is more likely than not.
Okay, just over 50% likely.
Essentially, yes. Consequently, evidence collection standards are generally less rigorous than in criminal cases. For instance, if one company claims another stole trade secrets via a cyber intrusion and they're seeking, say, financial damages or an injunction, that's typically a civil matter.
So it's not about putting someone in jail, but maybe winning a lawsuit or getting compensation for damages, like a business dispute.
Exactly. Think of it like a dispute over a property line between neighbors. It's a legal matter, definitely, but not one leading to criminal charges or incarceration. It's about dispute resolution and finding remedies. 2.5. Regulatory investigations. Next up are regulatory investigations. These are all about ensuring compliance with rules set by specific government bodies.
Ah, like the SEC or EPA.
Precisely. Conducted by government agencies like the Securities and Exchange Commission, the Environmental Protection Agency, maybe health departments. These investigations happen when an individual or a corporation is alleged to have violated administrative law or specific regulations.
Okay.
The proof standards can vary depending on the specific regulation and the agency involved. For example, if a financial institution fails to protect customer data as required by law, like GDPR or something similar, a regulatory agency might launch an investigation. The focus is purely on whether a specific regulation was broken. It's very much like a health inspector investigating a restaurant for violating hygiene codes. They're checking for adherence to specific published rules. 2.6. Industry standards investigations. And finally, many industries have their own rules, their own standards. This brings us to industry standards investigations.
Okay, not laws, but industry rules.
Exactly. These are based on industry-specific standards like the payment card industry, data security standard, PCI DSS.
PCI DSS,
Right.
credit cards.
PCI DSS. Yes, it applies to any organization that processes, stores, or transmits credit card data. These standards are technically contractual obligations, not laws necessarily, but they are incredibly important.
Why is that?
Because failure to participate in these investigations or negative investigation results can lead to very significant consequences. We're talking substantial fines, sanctions from payment card brands like Visa or MasterCard, or even losing the ability to process credit card transactions entirely.
Wow, that could cripple a business.
It absolutely could. So if a company handling credit card data violates PCI DSS, they might face an investigation by their acquiring bank or maybe an independent auditor. These are contractual obligations, not direct government laws, but the consequences can still be severe.
That's a really important distinction. So you could potentially be, fully compliant with the law, but still fail an industry standard investigation and face serious penalties, like legal driving versus safe driving.
Absolutely. The law often sets a baseline, right? But industry standards frequently raise the bar significantly for what's considered best practice or acceptable risk. You're right, it's a perfect analogy. Legally, you might be allowed to drive 60 miles per hour, but for safety in a heavy storm, an experienced driver might voluntarily choose to drive 40. Industry standards often push organizations to that higher bar of safe driving, even if the law allows a bit more leniency. 3. Electronic discovery and the EDRM.
Okay, so in our digital age, so much of our evidence is, electronic. We're talking emails, documents, server logs, chats, everything. What exactly is electronic discovery? Often called e-discovery, right? And how do we even begin to manage this absolute flood of digital information for legal purposes? It sounds like a massive undertaking.
You've hit on a crucial point. Electronic discovery, or e-discovery for short, is the formal process. It's about identifying, collecting, and producing electronically stored information, ESI, specifically for legal proceedings.
Right.
It's an absolutely critical process in civil and regulatory cases, and it demands very careful coordination between, IT professionals and legal counsel. They have to work together.
Right.
To help manage this complex process, the Electronic Discovery Reference Model, or EDRM, was developed. EDRM. It describes a standard process for e-discovery with 9 key aspects. Think of it like a roadmap, really, for handling digital evidence systematically from start to finish.
9 aspects. Okay, let's walk through that.
Sure. It provides a really logical flow for digital investigations that might end up in court. First, there's information governance. Now, this isn't just about the current case, it's more proactive. It's about ensuring information is well organized and managed before you even need it for e-discovery.
Like having a tidy digital filing system from day one.
Exactly. So you know where everything is when you eventually need it. Then we move to identification. This step involves locating potentially responsive information when litigation is likely or already happening. It's about knowing where to look when you suspect trouble might be brewing, finding all potential sources, laptops, cloud storage, everything.
Got it. Find the relevant stuff.
Next is preservation. This is absolutely crucial. It ensures that discoverable information, once you've identified it, is protected against alteration or deletion.
Freezing the data.
Essentially, putting a freeze on data. You issue what's called a legal hold, so it cannot be tampered with once it's deemed potentially relevant. Then collection follows. This gathers the relevant information centrally for the e-discovery process, collecting all the files, emails, logs, artifacts into one secure, forensically sound place.
Okay.
After collection, we have processing. This screens the collected information, performs a sort of rough cut of irrelevant data, significantly reducing the sheer volume for detailed review.
Sifting through the mountains of data.
Right, getting rid of the obvious junk or duplicate files. Then comes review. This involves human legal teams examining the remaining information for relevance to the case and critically carefully removing any attorney-client privileged information. That's legally protected.
Okay, the lawyers step in heavily here.
Yes. Carefully reading through, identifying what's pertinent, what needs to stay confidential. Analysis is next. Experts perform a deeper inspection of the content and context. This is where you really dig deeper, understand the story the data tells, look for patterns, timelines, connections.
Finding the narrative.
Right. Production is about placing the information into a specific, legally acceptable format to be shared with opposing counsel and other parties, like preparing the final documents, putting them in a specific binder according to legal specs.
Getting ready for court.
And finally, presentation. This is when the information is actually displayed to witnesses, the court, other parties during depositions, hearings, or the trial itself, actually showing the evidence.
That's incredibly comprehensive.
Yeah.
And I think that EDRM model really helps visualize the whole journey. You know, it sounds almost exactly like preparing a major academic research paper.
Oh, how so?
Well, information governance is how you meticulously organize your notes from day one. Identification is finding all the books and articles that might be relevant. Preservation is making sure you don't accidentally delete your research files. Collection is gathering everything into your workspace. Processing is sifting out the junk articles. Review is carefully reading the remaining sources. Analysis is forming your arguments. Production is formatting your paper perfectly. And presentation is giving your final speech or defending your thesis.
That is a perfect analogy. It truly captures the systematic nature of the EDRM. Each step builds on the last, ensuring not just efficiency, but crucially, the legal soundness and admissibility of that digital evidence.
Foundation of any case.
Okay, so once we have our e-discovery process humming along and we've gathered all this information, what truly makes that information useful as actual evidence in court? It's not just about having something, right? I mean, a random screenshot probably won't cut it.
Precisely. You've hit on a critical point. Not all information, not everything you collect, is admissible evidence in a court of law.
Right.
For evidence to be introduced, it has to meet 3 basic requirements. These are ultimately determined by a judge. Think of them like the 3 legs of a stool. If one's missing, the evidence just falls over. 4.1. Admissible evidence. The 3 pillars. First, the evidence must be relevant. What does that mean? It means it must logically tend to prove or disprove a fact in the case. Does it actually have anything directly to do with the issue at hand? If not, it's just noise.
Okay, relevance. Check. What's next?
Second, it must be material. This goes a step further. The fact that the evidence seeks to determine must be significant, important to the overall outcome of the case. Is it truly important, or is it just a minor tangential detail that won't really sway the decision?
So relevant and important. Got it.
And third, and this is crucial for us security professionals, it must be competent. Competent evidence means it must have been obtained legally and properly.
Ah, legally obtained.
Yes. Evidence resulting from, say, an illegal search would not be competent. It would therefore be inadmissible, no matter how relevant or material it might seem. That's why those proper procedures we discussed earlier are so incredibly vital.
Okay, if I'm thinking about that, it's like trying to put together a puzzle. Relevancy means a piece actually fits into the overall picture. Materiality means it's a piece of the actual puzzle you're working on, not some random piece from a different puzzle box. And competency means you got the piece from the original box, following all the rules, not by sneaking into someone else's house to steal a piece that happened to fit.
That's a fantastic way to visualize it. All 3 pillars, relevant, material, competent, must be met for evidence to be considered admissible in court. 4.2. Types of evidence. Different shapes and sizes. Beyond those 3 pillars of admissibility, evidence can also be grouped into 4 major categories based on its nature. We have real, documentary, testimonial, and demonstrative evidence.
Okay, 4 types. Let's break those down. 4.2.1, real evidence or object evidence.
Okay, first is real evidence, sometimes called object evidence. This category consists of actual physical objects that are brought into court.
Tangible stuff.
Tangible stuff you can touch. In computer cases, this might include a seized computer, a hard drive from a suspect's system, maybe even a keyboard with fingerprints on it. Depending on the circumstances, real evidence can sometimes be considered conclusive, meaning it's almost incontrovertible, like DNA evidence found on a device. That can be incredibly powerful.
So the actual baseball bat used in a crime or the physical hard drive that contained the malware.
Exactly. It's the actual item involved. 4.2.2, documentary evidence. Next is documentary evidence. This includes written documents or records brought into court to prove a fact. In our field, this is incredibly common.
Server logs, emails.
Server logs, system logs, emails, chat transcripts, contracts, reports, anything in written or recorded form. Now, for documentary evidence to be admissible, it must be authenticated.
Authenticated? How?
Often means a witness, like a system administrator, might need to testify. They'd say, this log was collected as routine business practice and it hasn't been altered, basically verifying its authenticity.
So if a firewall log clearly shows, say, 1 million failed login attempts from a specific IP address, that's documentary evidence.
Exactly. And there are two key rules that specifically apply to documentary evidence. Important to understand these. First, the best evidence rule.
Best evidence rule.
It states that, whenever possible, the original document must be introduced in court. The court prefers the most reliable, unaltered version. Unless there's a valid reason, like the original was destroyed or lost, or you have an authenticated copy that can be verified as identical, known as secondary evidence, a mere copy might not be accepted.
Okay, like a photocopied, will the court really wants the original if it exists?
Precisely. Second rule is the parole evidence rule. This applies when an agreement between parties has been put into written form.
Okay.
That written document is assumed to contain all the terms of the agreement. No prior verbal agreements or discussions can be introduced to contradict or modify it. You can't say, well, we also verbally agreed to something else if it's not explicitly in the written contract. The written word is generally considered the final word. 4.2.3, testimonial evidence. Third type, testimonial evidence. This is simply the testimony of a witness. It can be given verbally in court or as a written deposition beforehand.
What people say under oath.
Exactly. Witnesses must take an oath, agree to tell the truth, and generally must have personal knowledge to base their testimony on. They can offer direct evidence, which is based on their own direct observation, like an employee who directly witnessed a security breach.
I saw it happen.
Right. Or they can provide an expert opinion. This is based on their specialized knowledge in a certain field, like a forensic analyst explaining the intricate workings of a specific piece of malware.
So if someone is testifying, I saw them do it, that's direct evidence. But a forensic analyst explaining the mechanics of how a hack was executed, that's an expert opinion.
Precisely. And there's a key rule here called the hearsay rule. Generally, this rule prevents witnesses from testifying about what someone else told them.
Right, because you can't cross-examine the original speaker.
Exactly. The original speaker isn't there to be questioned for accuracy or truthfulness. However, and this is very important for us, there's a crucial business records exception to the hearsay rule.
An exception.
Yes. This exception allows computer system logs and other records that are collected as a regular course of business activity to be admitted as evidence, provided they are properly authenticated and shown to be reliable. This is critical for using all those digital logs we collect day in, day out. 4.2.4, demonstrative evidence. And finally, the fourth type is demonstrative evidence. These are items used to support testimonial evidence, maybe explain a complex concept, or clarify an issue for the court.
Visual aids.
Essentially, yes. Visual aids. They are not admitted as evidence themselves. Rather, they serve to help the jury or judge understand complex technical concepts. Examples include diagrams, models, charts, even animations.
So a diagram of a distributed denial of service attack, a DDoS attack showing all the zombie computers flooding a server with traffic. That would be demonstrative evidence. It's not the proof itself, but it helps explain the proof.
Exactly. It helps visualize the attack, making a complex technical scenario understandable. But you're right, the diagram itself isn't the proof. It's the explanation of the proof that the other types of evidence, like network logs, actually provide. 5. Chain of evidence, chain of custody, preserving integrity.
This gets really interesting. Okay, we have all of these types of evidence, from physical hard drives to digital logs. How do we make absolutely sure it's not tampered with or accidentally changed or compromised before it gets to court? This seems like a massive challenge, keeping track of everything.
You've hit on one of the most critical aspects of any investigation, especially digital ones. the chain of evidence. It's also widely known as the chain of custody.
Chain of custody.
It is absolutely paramount for any evidence that might be used in court, particularly real or physical evidence. What is it? It's an unbroken, meticulously documented sequence of events detailing who had access to the evidence, where it was, and what happened to it, from the moment it was collected until it's presented at trial.
Unbroken. So what specific information is vital to keep this chain solid? What needs to be recorded?
The chain of custody documents literally everyone who handles the evidence.
Everyone.
Everyone. From the initial police officer or incident responder who collects it, to the forensic technicians who analyze it, to the lawyers who use it in court. It ensures its location and integrity are fully documented every single step of the way.
Okay.
When evidence is properly labeled to preserve this chain, the label must include a precise general description of the evidence, the exact time and date it was collected, the precise location it was collected from, the full name of the person collecting it, and any relevant circumstances surrounding the collection, like initial observations.
Right.
And then each person who subsequently handles that evidence must sign the chain of custody log. They indicate their responsibility, the exact time they took possession, and when they handed it off to the next person. This level of transparency is vital for legal admissibility.
So it's like a priceless, valuable artifact being moved from an ancient excavation site to a museum. Every single person who touches it, every vehicle it's transported in, every storage location, all of it must be meticulously recorded. If there's even a tiny gap in that record, the artifact's authenticity and integrity can be immediately questioned.
That's a perfect analogy.
So in cybersecurity, if someone could argue that maybe a hard drive or log file might have been tampered with because the chain was broken, that evidence essentially becomes useless in court.
It can be, yes. An unbroken chain of custody is paramount to its admissibility and its credibility in any legal proceeding.
Yeah.
Without it, even really compelling evidence can be dismissed. 6. Artifacts, evidence collection, and forensic procedures.
Okay, so the evidence itself, these artifacts, where do we actually find them in the digital world? And what are the specific techniques and rules for collecting and analyzing them without, screwing up the evidence or breaking that chain of custody?
That's where the true art and science of digital forensics really come in. Digital evidence collection is a tricky process. It should only be attempted by trained professional forensic technicians.
Right, not something you just try yourself.
Definitely not. It requires specialized tools and adherence to very strict protocols. The International Organization on Computer Evidence, or IOCE, outlines 5 core principles that guide these digital evidence technicians in forensics. Think of these as the golden rules for operating in this space.
Okay, what are they?
First, upon seizing digital evidence, actions taken should not change that evidence. Preserve its original state. Second, when it's necessary to access original digital evidence, which you generally try to avoid, the person doing so must be forensically competent. They need the training and tools to do it without altering anything.
Makes sense.
Third, all activity relating to the seizure, access, storage, or transfer of digital evidence must be fully documented, preserved, and available for review. That goes right back to our chain of custody.
Right. Document everything.
Fourth, an individual is responsible for all actions taken with respect to digital evidence while it is in their possession. Personal accountability is key. And finally, any agency responsible for seizing, accessing, storing, or transferring digital evidence is responsible for ensuring compliance with all these principles. It's an organizational responsibility, too.
Those principles sound exactly like the golden rules for a crime scene investigator, don't they? Don't touch anything without gloves. Only trained personnel should handle it. Document everything meticulously, take personal responsibility, and make sure the entire process follows all protocols to the letter. It's all about maintaining the integrity of the scene.
Precisely. They're designed to ensure the evidence remains untainted and ultimately admissible. Now, let's talk about the specific techniques we use for the analysis itself. 6.2. Forensic Analysis Techniques. We employ several specific techniques for digital forensic analysis, each suited to different types of digital artifacts. 6.2.1. Media Analysis. First is media analysis. This technique involves identifying and extracting information from storage media, hard disks, solid-state drives, tapes, optical media, even USB flash drives.
All the places data lives.
Right. When gathering information from these devices, analysts should never access them directly from a live or running system. That could inadvertently alter the evidence.
Okay, so power it down first.
Power it off, physically remove the storage device, and attach it to a dedicated forensic workstation. Now, this workstation uses a special piece of hardware called a write blocker.
Ah, the write blocker, we mentioned that.
Yes. It's a hardware adapter that physically severs the connection that would allow data to be written to the drive. It effectively prevents any accidental tampering or modification of the original evidence.
So it's essentially like a digital one-way valve. You can only read data from the original drive. You can't change or write anything to it.
Exactly. Once it's connected through the right blocker, we create what's called a forensic image. This is a bit-by-bit exact copy of the original drive,
An identical twin.
an identical twin. After creating this image, the analyst immediately calculates a cryptographic hash of both the original drive's contents and the forensic image.
The digital fingerprint.
The unique digital fingerprint, yes, a cryptographic hash. Even a single bit change of the data would result in a completely different hash value. So if the hashes match, we know the copy is identical to the original, hasn't been altered during imaging. This is fundamental for preserving that chain of custody.
Right.
This process also allows us to potentially recover deleted files or information from unallocated sectors of the disk, which often hold fragments of critical data.
So it's like carefully copying a fragile ancient scroll. The right blocker ensures you don't accidentally write on the original, and the hash is like taking a high-res photo of both the original and the copy to prove they are identical down to the finest detail.
That's a perfect analogy for media analysis. 6.2.2, in-memory analysis. Now this next one, in-memory analysis, is particularly tricky but incredibly valuable. It involves collecting information from the volatile memory of live systems, specifically random access memory, or RAM.
RAM! Okay, tricky because it disappears when you power off?
Exactly. Memory contents are volatile, gone as soon as the system powers off. Investigators use trusted, forensically sound tools to generate a memory dump. That's essentially a snapshot of the RAM contents at a specific moment in time.
The snapshot.
This dump is then immediately saved to a forensically prepared storage device, often a USB drive. This kind of analysis can reveal critical information running processes, active network connections, open files, maybe even encryption keys that might not be found on the hard drive because they only exist in memory while the system is running.
Here's where it gets really interesting. So it's like capturing the thoughts or the active processing of a computer right before it has a chance to forget them, a glimpse into its immediate state.
Precisely. It's capturing the computer's working memory before it vanishes. It provides a critical insight into its operational state at the exact moment of collection, often crucial for understanding malware behavior or an attacker's immediate actions. 6.2.3. Network analysis. Network analysis is all about reconstructing activity from network data. It's especially critical for understanding security incidents like intrusions. Now, this can be quite difficult if network data isn't deliberately recorded over time.
Right, you need the logs or captures.
You do. Forensic analysts rely on various sources, intrusion detection and prevention system logs, network flow data, which provides summaries of network conversations, full packet captures collected during an incident, and logs from firewalls and other network security devices. When collecting network data directly from a live network for an investigation, forensic technicians might use a switched port analyzer, that's SPAN, a span port on a network switch. This mirrors traffic from one or more ports to another designated port for analysis.
Mirroring the traffic.
Or alternatively, they might use a network tap. This is a hardware device that physically intercepts network traffic. Both approaches generate packet dumps, essentially recordings of all data packets traversing that network segment without altering the actual network traffic being exchanged between systems.
Got it.
This helps us reconstruct the attack's path, see what data was maybe exfiltrated, and understand the attacker's specific actions on the network. It's like analyzing traffic camera footage, phone records, and postal service logs to reconstruct someone's movements and communications. You're piecing together the journey of data across the network. 6.2.4. Software analysis. Software analysis delves into the applications or processes themselves. It can involve reviewing source code for hidden functionalities like backdoors, logic bombs, or vulnerabilities, especially if, say, a malicious insider is suspected of manipulating software.
Looking inside the code.
Exactly. A crucial tool here is the National Software Reference Library, or NSRL. This is maintained by the National Institute of Standards and Technology, NIST.
NIST, okay.
The NSRL provides cryptographic hash values for millions of known, legitimate applications and operating system files. We can compare the hash of a suspicious file found on a compromised system to the NSRL to quickly determine if it's a legitimate, untampered version, or if it has been manipulated, or if it's a known malicious executable.
So it's like a digital fingerprint database for software. You check a program's fingerprint against this huge database, and it tells you if the program is what it claims to be or if it's been messed with by an attacker.
Spot on. It's an essential step for detecting authentic versus manipulated or malicious files. Very powerful, 6.2.5. Hardware embedded device analysis. And finally, hardware and embedded device analysis. This expands forensics beyond just servers and traditional desktops. It involves reviewing the contents of a vast array of hardware and embedded devices, personal computers, smartphones, tablets, specialized embedded systems found in cars, industrial control systems, even smart home security systems.
Wow, everything's a computer now.
Pretty much. Mobile forensics specifically is a huge and rapidly growing field, examining data from phones, often recovering deleted messages, location data, app usage.
Yeah, that's huge.
Even smart devices and Internet of Things IoT devices can hold crucial evidence about someone's activities or an attack. This type of analysis requires highly specialized knowledge of these diverse systems and their unique store-of methods. It's like a mechanic examining the black box of an airplane or a vehicle's onboard computer after an incident. You're digging into these specialized systems to find the truth. 6.3. Locard's exchange principle in the digital world. Now, tying all these collection and analysis techniques together is a core principle in forensics. It was originally articulated by Dr. Edmund Locard. His principle famously states, every contact leaves a trace.
Every contact leaves a trace. Okay.
In digital forensics, this holds absolutely true. Whenever two objects interact, for instance, an attacker interacting with a computer system, there will inevitably be some digital evidence left behind, some trace. This principle applies perfectly even to subtle attacks like a structured query language SQL injection, SQL injection.
Okay, SQL injection. That's where they try to trick a database into revealing information by feeding it malicious code, right?
Yeah.
So what does that trace look like in practice across different systems following Locard's principle?
Let's break down that SQL injection attack scenario to illustrate it. You'll see traces left in multiple interconnected places. First, on the attacker's device. There will be logs on their laptop, desktop, smartphone, maybe a virtual server, showing the tools used, the commands executed, the network connections made to launch the attack.
Okay, on their machine.
Right. If law enforcement gets their hands on it, there might even be physical fingerprints on the device, or maybe evidence caught by a security camera observing the attacker. Then, on the network infrastructure used to reach the target, there could be traffic logs from maybe a coffee shop, wireless fidelity, Wi-Fi network.
Wi-Fi logs, yeah.
Or an airport Wi-Fi hotspot, firewall logs, intrusion prevention system logs, application firewall logs. Each of these devices could have identified portions of the attack traffic and kept records. The web server that hosts the application being attacked would likely have logging configured to capture the actual requests received during the attack.
Ah, the web server logs. Goldmine.
Absolute goldmines. They could be used to reconstruct the precise commands sent by the attacker, including that malicious SQL code. And finally, the database server itself, the ultimate target of the injection, may also have relevant information. If logging is enabled on the database system,
Which it should be.
hopefully, you'll be able to reconstruct the attacker's actions within the database, seeing what queries were run, what data was accessed, maybe what changes were attempted.
So it's not just about finding one single smoking gun, but rather piecing together all the little bits of contact from the attacker's keyboard to the network they used to the web server and finally the database they hit to tell the complete, coherent story of what actually happened.
Exactly. Every click, every packet, every log entry is a digital trace. Our job as forensic experts is to meticulously discover and interpret those traces to understand precisely what took place. What's truly fascinating here is how this principle reinforces the idea that there are always multiple, often independent, sources of information to piece together during an investigation. It builds a complete and hopefully undeniable picture of events. 7. The investigation process. A step-by-step guide.
Okay, this is a lot to consider. From different types of investigations to how we collect and analyze all these digital artifacts. Once an incident actually happens, what's the structured process we follow? How do we conduct an investigation properly and legally? You don't just dive in head first, right?
Absolutely not. When you initiate a computer security investigation, you do not go it alone, and you definitely don't improvise. It starts with forming a competent team and defining the scope very, very clearly. 7.1. Investigation team and charter. First, you need to assemble a dedicated team, competent, trained analysts. This team operates under the organization's existing incident response policy. Hopefully they have one.
Hopefully.
And critically, under a formal charter. This charter is a foundational document. It explicitly outlines the investigation's scope, delineates the team's authority, defines individual roles and responsibilities, and sets clear rules of engagement.
So the charter is like the mission statement and the legal mandate for the investigation.
Exactly. It empowers the team while simultaneously setting clear boundaries. It ensures everyone involved knows what they can and cannot do, really helps prevent scope creep, and ensures legal compliance from the get-go. 7.2. Gathering evidence. Legal avenues. Now, the manner in which evidence is confiscated is critically important for its legal admissibility later on. There are several well-defined legal approaches to obtaining equipment and software, and understanding these is absolutely key.
Okay, the legal ways to get the evidence.
Right. First, voluntary surrender. This is the simplest. The owner just consents to surrender the evidence. This is often the best-case scenario for internal investigations, especially if an employee knows they're suspected and decides to cooperate. Less experienced attackers might even surrender evidence voluntarily.
Okay, they just hand it over.
Second, a subpoena. This is a formal court order compelling an individual or organization to surrender specific evidence. It's typically served by law enforcement and provides sufficient notice to the recipient, which ideally prevents someone from altering the evidence after receiving the order.
A court order. Got it.
Third, the plain view doctrine. This is a legal principle allowing law enforcement to seize evidence that is clearly visible in plain view, if there's probable cause to believe it's connected to criminal activity.
So if they're legally somewhere and see something illegal just sitting out.
Exactly. If an officer is lawfully in a room and sees illegal contraband openly displayed on a desk, they can seize it without needing a separate warrant for that item. Fourth, a search warrant. This is a powerful legal document. It requires probable cause, meaning sufficient evidence of a crime, and judicial approval to access evidence that is not in plain view. We'll delve deeper into warrants shortly. They have strict requirements.
Right.
Fifth, exigent circumstances. This is an exception. It allows law enforcement to collect evidence without a warrant in emergency situations.
Emergencies like what?
Scenarios where there's an immediate threat, maybe a risk of immediate destruction of evidence or a risk of physical harm to individuals. The urgency justifies bypassing the typical warrant process. And finally, employee agreements. Many companies include clauses in their employment agreements giving consent to search company-owned equipment.
Right, the fine print when you get hired.
Exactly. While this can ease confiscation during internal investigations, it's vital to remember that it doesn't always override an employee's personal expectation of privacy. That varies significantly by jurisdiction. It's a very nuanced area.
Okay, so it's not just about finding the data, but how you legally get access to it. What stands out to you as the most critical point for security professionals regarding these different methods?
The absolutely crucial takeaway is understanding the legal basis for gathering evidence. You cannot simply demand it or take it. Each method has strict rules. For employees, yes, companies often proactively build consent to search corporate devices into employment agreements. However, as I mentioned, this doesn't always apply to that complex legal concept of an employee's personal expectation of privacy. It depends on local laws, specific circumstances.
Tricky.
Very. My strong advice is always consult an attorney for any searches in the workplace, especially when dealing with complex or nuanced situations. You want to ensure you don't invalidate your findings later. Think of these as different keys to unlock a door. Some doors open voluntarily. Some need a judge's order like a subpoena or warrant. Some are already open for all to see like plain view. And some, well, they can be forced open in an emergency due to exigent circumstances. 7.3. Calling in law enforcement. Now, deciding whether to actually call in law enforcement like the FBI, Federal Bureau of Investigation, or the USSS, United States Secret Service, both specialize in cybercrime, that's a very complex decision.
Right, not taken lightly.
Not usually taken by the security professional directly investigating either. It's often made by senior management. Two main factors heavily influence this decision. First, whether the investigation is likely to become public and potentially embarrass the company, causing reputational damage.
The PR aspect.
The PR aspect, yes. And second, whether the company's own private investigation might inadvertently conflict with legal requirements, like the Fourth Amendment of the U.S. Constitution, which protects against unreasonable searches. You don't want your internal actions to jeopardize a potential criminal case.
So what does this all mean for us as security professionals, especially if we're dealing with an incident that looks like it might be criminal?
It means having an established relationship with law enforcement before an incident occurs could be invaluable.
Be proactive.
Be proactive. Programs like the FBI's InfraGard, for example, are fantastic ways to establish technical contacts within the FBI and share information in a closed, trusted environment. This proactive relationship can simplify communication, information sharing, and coordination immensely should a serious incident occur. Makes the whole process smoother and more effective when you already know who to call. 7.4. Search warrants. A deeper look. Let's delve just a bit deeper into search warrants because they're so important legally. A search warrant is essentially a judge's permission slip for law enforcement to search private property.
Okay.
It is fundamental to protecting a person's privacy under the Fourth Amendment of the U.S. Constitution. That amendment specifically safeguards citizens against unreasonable searches and seizures.
The Fourth Amendment. Right.
A warrant must be supported by an oath or affirmation, a sworn statement. And it must particularly describe the place to be searched and the persons or things to be seized. It has to be specific. It cannot be vague or open-ended.
No fishing expeditions.
No fishing expeditions. Most importantly, it must be based on probable cause. That means there's sufficient objective evidence to believe a crime took place, and that evidence related to that crime will likely be found at the location to be searched.
So a judge issues a warrant like a very specific grocery list. You can search for these specific items in this specific aisle at this specific time for this specific reason, not just go search the whole store for anything suspicious. Is that right?
That's an excellent way to conceptualize it. If investigators fail to comply with even the smallest detail of these provisions, say searching an area not specified or seizing items not listed, they may find their warrant invalidated, and any evidence obtained from that faulty search could be deemed inadmissible in court. The precision is absolutely paramount. 7.5. Conducting the investigation. Key principles.
Okay.
Now, whether or not law enforcement is involved, internal investigations must always adhere to fundamental principles: accuracy, fairness, legal compliance.
Okay.
First, and this is crucial, never conduct an investigation on the actual system that was compromised.
Don't touch the original crime scene.
Exactly. Always make a forensic image or a bit-by-bit backup of the compromised system first. Immediately take the original system offline. Conduct your investigation using the backup or the image. This preserves the original evidence in its untouched state.
Makes sense.
Second, never ever attempt to hack back or avenge a crime by attacking the perpetrator's system.
No vigilante justice.
Absolutely not. It is highly illegal. It can make your organization liable for new criminal charges. And you could inadvertently attack an innocent third party if the attacker was routing their traffic through some other compromised system. Big mistake.
Okay, definitely don't do that.
And third, if you are in any doubt about how to proceed, or if an incident seems beyond your team's capabilities, always call for expert assistance, whether that's law enforcement or a private investigations firm with specific experience in computer security investigations. Know your limits.
So no vigilante justice, don't mess with the original crime scene, and know when to call for help.
Precisely. Maintain forensic integrity, avoid self-incrimination or creating new liabilities, and know when to call in the cavalry. 7.6. Interviewing individuals. When it comes to gathering information from people, the distinction between an interview and an interrogation is absolutely critical. They require different approaches, different training.
Interview versus interrogation. What's the difference?
An interview is conducted to gather information from someone who might assist with the investigation, maybe a witness, or someone who might have relevant knowledge but isn't suspected of wrongdoing. An interrogation, on the other hand, is specifically to gather information from someone who is suspected of involvement in a crime.
Okay, very different intent.
Very different intent. Interviewers must be trained. They often use structured checklists to ensure all points are covered. And they should customize their approach based on the individual's behavior and willingness to cooperate. Interrogating individuals, however, that requires highly specialized skills. It should only be performed by trained law enforcement investigators and always with legal counsel present. Improper techniques can easily jeopardize a prosecution and violate an individual's rights.
So an interview is like asking a witness, what did you see happen? An interrogation is more like asking a suspect, why did you do it? The focus and the legal stakes are completely different.
That's a very clear way to put it, and the legal implications are vastly different as well. You need to know which one you're doing. 7.7. Data integrity and retention. Maintaining data integrity is crucial for any persuasive evidence, particularly in cybersecurity. Why? Because attackers are constantly trying to cover their tracks by altering or deleting log files.
Right, erasing the evidence.
Exactly. To protect against this, one highly effective technique is to implement remote logging. This is where all systems send their log records to a hardened, centralized log server that's separate from the systems generating the logs.
So the logs are safe even if the original machine is compromised.
Correct. It prevents an attacker from modifying logs on the compromised system itself because the original unpainted logs are stored safely elsewhere. We can also use digital signatures, often part of a public key infrastructure PKI system, to cryptographically verify that logs haven't been tampered with after their initial capture. This provides an indisputable record of integrity.
What's fascinating here is how much effort goes into not just collecting logs, but protecting them even after they're collected. It's like putting them in a tamper-proof safe as soon as they're created.
Absolutely.
Yeah.
A log file that can be easily modified is next to useless as evidence. You must be able to prove the integrity of every piece of data you've collected from the moment it was created right up until you present it. 7.8. Reporting and documenting investigations. Okay, so every investigation eventually concludes with a formal report. This final report meticulously details the goals of the investigation, the procedures followed, all the evidence collected and analyzed, and the final conclusions or findings.
The wrap-up.
The wrap-up. Now, the formality and the level of detail in this documentation depend heavily on the organization's policies and the nature of the investigation itself. An internal administrative report will look very different from a report prepared for legal action in court. However, formal documentation is vital for any potential legal escalation. It serves as the official record of everything that happened. It's very much like a doctor's complete medical record. It details the patient's symptoms, the diagnostic process, all the findings, the final treatment plan. It needs to be precise, factual, and easily understandable for anyone who might review it later, from a manager to a judge. 8. Major categories of computer crime. Understanding the motives.
Okay, we've covered how to investigate incidents in pretty good detail. Now let's get into what we're investigating. What are the major categories of computer crime? And maybe even more importantly, what really drives these attackers? Understanding their motives must be crucial for defense.
You're absolutely right. Understanding the motivations behind attacks is crucial for effectively protecting systems. Computer crime. Well, it's essentially any crime or violation of law or regulation that involves computers either as the instrument of the crime, the target, or sometimes both. We can group these crimes into several distinct categories based on their primary purpose and intended result. Knowing why an attacker is doing something really informs how you defend against it. 8.1. Military and intelligence attacks. These are some of the highest stakes attacks. They're launched primarily to obtain secret and restricted military or intelligence information.
Nation-states.
That's it.
Espionage. Often conducted by nation-states, yes. Or state-sponsored groups, sometimes highly organized terrorist or criminal organizations. They frequently employ what are called advanced persistent threats, APTS.
APTs. Yeah.
These are sophisticated, long-term attack campaigns. They're designed not just to infiltrate deeply, but to maintain a persistent, stealthy presence within a target's network, often for years, continuously exfiltrating sensitive data. Their aim could be stealing defense secrets, troop deployment plans, credible infrastructure designs, very sensitive stuff.
So these aren't just quick one-off hacks, but highly coordinated, extremely patient campaigns that can unfold over a very long time. That sounds terrifying. Precisely. They are very goal-oriented. They often involve significant technical resources, deep intelligence gathering beforehand, and extreme patience. Their objective is long-term access and intelligence gathering, not just quick hits. 8.2. Business attacks. This category covers attacks aimed at illegally jeopardizing the confidentiality, integrity, or availability, the CIA triad of business information or systems.
Okay, targeting businesses directly.
Yes. A classic example is corporate espionage. Stealing trade secrets, proprietary research, confidential business information, usually by competitors or other malicious actors trying to gain a competitive advantage.
Right.
Another major threat in this category is ransomware. We hear about this all the time. Attackers disrupt business operations by encrypting critical data and then demanding payment, usually in cryptocurrency, for its release. They effectively hold the organization's data hostage.
So these are like industrial spies trying to steal a secret recipe or a vandal holding a factory's production line hostage for money. It's all about impact on the business operations or their intellectual property.
A very apt comparison. It's direct financial or competitive harm to an organization. 8.3. Financial attacks. Next, financial attacks. These crimes are carried out explicitly to unlawfully obtain money or services.
Straight up theft.
Straight up theft, basically. Common examples include large-scale credit card number theft, fraudulently increasing bank balances, initiating unauthorized financial transfers.
Yeah.
These attacks can range from relatively low-level digital shoplifting to highly sophisticated operations that siphon tiny amounts from many transactions, accumulating to millions.
Okay.
Interestingly, less sophisticated attackers often engage in what's called cybercrime for hire. They perform tasks like distributed denial of service, DDoS attacks for a fee on behalf of someone else, maybe targeting a competitor or a perceived enemy.
So a DDoS attack, where a website is flooded with so much traffic it crashes and becomes unusable, that could definitely be a financially motivated attack. To extort money, maybe?
Absolutely. It could be used to extort money from a company by disrupting their services until they pay. Or it could be a strategic move to disrupt a competitor's online sales during a crucial period, like a major holiday shopping season. The goal is direct monetary gain or disruption for profit. 8.4. Terrorist attacks. Terrorist attacks. These have broader societal impact. They're designed to disrupt normal life, threaten national security, or maybe extract secret information to further a political or ideological agenda.
Targeting critical infrastructure.
Often, yes. Their targets are frequently critical national infrastructure, telecommunications networks, power distribution grids, transportation systems, emergency services. They aim to instill widespread fear and chaos. In some severe cases, multiple physical and computerized attacks might be launched simultaneously to achieve maximum synchronized impact.
So we're talking about like a digital bomb designed to knock out a city's power grid, causing widespread chaos and fear. The impact is far beyond just data or money.
That's essentially the intent. It's about causing large-scale disruption and significant psychological impact. 8.5. Grudge attacks. The insider threat. Grudge attacks. These are carried out to damage an organization or maybe a specific person within it, often by disgruntled current or former employees.
The insider threat.
The classic insider threat. The motivation is typically resentment, a desire for revenge, a feeling of getting back at the organization. This often comes from insiders who, because of their privileged access and intimate knowledge of systems, can cause disproportionate damage.
Yeah, they know where the skeletons are buried.
They do. Let me give you a simplified case study from the source material that really highlights this danger. Imagine a former system administrator, fired on unfavorable terms, leaves with a significant chip on his shoulder.
Okay.
He supposedly removed all traces of his access upon termination, or so the company thought. But due to an immature or incomplete deprovisioning process, maybe an account was missed. Some residual access remained.
Yeah.
This former admin then used a virtual private network, VPN, to secretly access the corporate network and committed serious security breaches. Theft of thousands of dollars, destruction of critical corporate information.
Wow.
This really highlights the severe danger of the insider threat and the critical need for robust access controls, meticulous deprovisioning processes, and diligent monitoring. It's also worth remembering, not all insider attacks are malicious like this. Sometimes privileged access, even if unintentional, can create vulnerabilities that lead to an incident.
Here's where it gets really interesting. So the biggest threat can often come from within, from someone who knows the system intimately and has a motive. It's not always the shadowy threat from outside.
It's a classic and enduring challenge in cybersecurity. Employees with privileged access, especially former ones who might still have residual access, pose a significant risk because they know exactly where the weak points are. Diligent monitoring, quick and thorough deprovisioning of accounts upon termination, robust vulnerability assessments. These are absolutely key to mitigating these kinds of grudge attacks. 8.6. Thrill attacks. Then we have thrill attacks. These attacks are launched purely for the fun of it, for the high of successfully breaking into a system, or maybe just for bragging rights amongst peers.
Not for money or secrets.
Nope. Often carried out by script kiddies, individuals who use pre-made programs or scripts to launch attacks without necessarily having deep technical knowledge themselves. They're more about the outcome than the technical process. A common type of thrill attack is website defacement.
Right, changing the homepage.
Exactly. They compromise a website and replace its content with their own, simply for notoriety or the challenge of having done it.
So it's very much like a graffiti artist tagging a wall, just for the notoriety or the challenge of leaving their mark, rather than any financial gain or specific intelligence.
Exactly. The main motivation is the thrill and the recognition.
Yeah.
8.7. Hacktivist attacks. And finally, we have hacktivist attacks. The term hacktivist, as it sounds, is a combination of hacker and activist. They organize loosely into groups and use hacking techniques, like denial of service DOS attacks, to disrupt organizations they differ with philosophically or politically. They use their technical skills to advance a social or political agenda, often targeting corporations or governments.
Right.
While they often operate under the banner of a cause, their actions can still cause significant damage, disrupt legitimate services, and are, of course, illegal.
So it's like digital protest or maybe digital civil disobedience, but using hacking tools and potentially having much broader impact.
That's a good way to describe it, yes. Their goal is usually to make a statement, disrupt operations, and draw attention to their cause rather than to profit or steal secrets directly.
The moral compass of cybersecurity.
Okay, we've navigated the complex world of digital investigations and all the various categories of computer crimes. It's clear that these actions have real-world consequences, and how we handle them matters deeply. But none of this works, right? None of it truly holds up without a strong ethical foundation. What does ethics truly mean for a security professional, beyond just following the law?
You've hit on the bedrock of our profession, ethics. They are the moral codes, the rules of personal behavior that guide our day-to-day activities, especially when we are in positions of trust.
Right. Trust is key.
In cybersecurity, ethical conduct isn't just a nice guideline, it's absolutely fundamental. Fundamental to maintaining public trust, protecting sensitive information, and upholding the integrity of our entire profession. Security professionals really hold themselves, or should hold themselves, to a very high standard precisely because of the sensitive positions they occupy and the access they have to critical systems and data. 9.1. Organizational Code of Ethics. Most organizations, regardless of industry, have their own code of ethics to guide employees.
Company rules.
Yeah, it's often published as an official statement or embodied in policies and procedures. It establishes clear behavioral expectations for everyone within the company. For example, in the United States, the U.S. government actually has a code of ethics for government service. It was written into federal law, passed by Congress way back in 1980.
Wow. Okay.
This code outlines principles like loyalty to the highest moral principles and the country, upholding the U.S. Constitution, laws, regulations, giving a full day's labor for a full day's pay, seeking efficient ways of doing tasks, never discriminating unfairly, making no private promises binding on public duty, avoiding business inconsistent with government performance, never using confidential information for private profit, exposing corruption, and ultimately upholding these principles, seeing public office as a public trust. Pretty comprehensive.
So an organizational code of ethics is kind of like a company's internal constitution,
Yeah.
setting the behavioral expectations for everyone, guiding their decisions.
Exactly. It's about aligning individual actions with organizational values and legal obligations, ensuring sound and ethical judgment at every level, especially when dealing with sensitive information or critical systems. 9.2. ISC Code of Professional Ethics. Now, this next ethical framework is perhaps the most significant for many of our listeners, especially those pursuing or holding the Certified Information Systems Security Professional CISSP certification.
CISSP.
The International Information Systems Security Certification Consortium, ISC, which is the governing body administering the CISSP certification, developed this code. It's the fundamental basis for CISP behavior.
Okay.
It's a beautifully simple code, actually. A preamble and 4 core canons. More than just a suggestion, strict adherence to this code is actually a condition of certification and maintaining your professional standing.
Not optional, then.
Not optional at all. The preamble emphasizes safety, welfare, the common good, necessary public trust and confidence, and adherence to the highest ethical standards, sets the overarching tone. And then the 4 canons provide the actionable principles. Canon is first, protect society, the common good, necessary public trust and confidence, and the infrastructure. This means our primary duty extends beyond our immediate employer, out to the public at large. It emphasizes the huge social responsibility inherent in our work.
Wow, that's big. Protect society.
It is. Canon the second. Act honorably, honestly, justly, responsibly, and legally. This focuses on individual integrity and adherence to the law. Stresses that personal integrity is absolutely essential. Canon the third. Provide diligent and competent service to principals. This is about commitment to professional excellence for our employers and clients, providing unbiased, competent, thorough service, continuously improving our skills. And Canon the fourth. Advance and protect the profession. This mandates continuous learning, sharing knowledge, and upholding the profession's reputation, ensuring our knowledge stays current, contributing back, and conducting ourselves in a way that elevates the entire field.
Okay, let's unpack this. So this isn't just a suggestion you read once and forget. It's truly foundational for anyone getting their CISSP certification and keeping it right. It sounds like a professional oath.
Exactly. Think of it as the Hippocratic Oath for cybersecurity professionals. It's not merely a guideline, it's a fundamental requirement for licensure and continued certification. It demonstrates a commitment to the highest professional and ethical standards. 9.3. Code of Ethics Complaints. So, what happens if someone violates this code? If an ISC member violates the Code of Professional Ethics, there is a formal complaint process.
Okay, there are consequences.
Definitely. Other members or affected parties can report potential violations. The complaint needs to identify the specific canon believed to be violated. The type of complaint, whether it relates to personal injury, canons thus or 2, an employer-contractor relationship, canon the 3rd, or general professional behavior licensure, canon the 4th, determines the path the investigation takes. A formal investigation is then undertaken by ISC, which can lead to sanctions, potentially up to and including the revocation of their certification.
Wow, revocation. That's serious.
It's a very serious matter. Reflects the weight placed on ethical conduct in this profession. 9.4. Ethics and the Internet, RFC 1087. Let's go back in time a bit again. Way back in 1989, the Internet Architecture Board, IAB, recognized the rapidly expanding Internet and saw the need for ethical guidelines for its use.
1989, early days.
Very early days. This led to Request for Comments 1087 RFC 1087 titled Ethics and the Internet. This document outlines activities considered unacceptable and unethical back then, and honestly, many of these principles still resonate strongly today.
What did it say?
It serves as a brief list of practices considered unethical, things you should not do. It's unethical to seek unauthorized access to internet resources. It's unethical to disrupt the intended use of the internet. It's unethical to waste resources, people's time, network capacity, computer processing power through your actions. It's unethical to destroy the integrity of computer-based information. And it's unethical to compromise the privacy of users.
So even basic things like wasting network resources by intentionally flooding them or trying to guess someone else's Wi-Fi password, that would be considered unethical under this framework, even though it's from 1989.
Indeed. It's a broad foundational statement about responsible digital citizenship and maintaining the integrity and intended use of the internet. Principles that remain timeless, really, even as the technology has exploded. 9.5. 10 Commandments of Computer Ethics. Further reinforcing these ideas, the Computer Ethics Institute created a simple, yet pretty profound set of rules known as the 10 Commandments of Computer Ethics.
The 10 Commandments, okay.
These are almost common-sense guidelines that apply to all computer users. 1. Thou shalt not use a computer to harm other people. 2. Thou shalt not interfere with other people's computer work. 3. Thou shalt not snoop around in other people's computer files. 4. Thou shalt not use a computer to steal. 5. Thou shalt not use a computer to bear false witness, like spreading misinformation.
Relevant today.
Very. 6. Thou shalt not copy or use proprietary software for which you have not paid. 7. Thou shalt not use other people's computer resources without authorization or proper compensation. 8. Thou shalt not appropriate other people's intellectual output, plagiarism, stealing ideas. 9. Thou shalt think about the social consequences of the program you are writing or the system you are designing. And 10. Thou shalt always use a computer in ways that ensure consideration and respect for your fellow humans.
These really are like the 10 Commandments, but for the digital world.
Exactly.
Simple, direct, yet profound rules for responsible behavior that kind of transcend specific technologies.
Exactly. They boil down ethical computer use to fundamental human principles. Be decent online, basically. 9.6. Code of Fair Information Practices. And finally, let's discuss the Code of Fair Information Practices. This was developed by a government advisory committee way back in 1973.
1973? Wow, even earlier.
Even earlier, long before the widespread adoption of the internet. Yet it outlines 5 fundamental principles for handling personal information ethically and responsibly that are incredibly relevant today. Foundational, really.
What are the principles?
1. There must be no personal data record-keeping systems whose very existence is secret. People have a right to know what data is being collected about them. Transparency. 2. There must be a way for a person to find out what information about them is in a record and how it is used, access, and knowledge. 3. There must be a way for a person to prevent information obtained for one purpose from being used for other purposes without their consent. That's purpose limitation and consent.
Huge today with privacy laws.
Absolutely. 4. There must be a way for a person to correct or amend a record of identifiable information about them, ensures data accuracy, the right to rectification. And 5. Any organization creating, maintaining, using, or disseminating records of identifiable personal data must assure the reliability of the data for its intended use and take precautions to prevent misuses. That's about data quality and security.
What's truly fascinating here is how these principles from 1973 still feel incredibly relevant today. Even with all our modern data privacy concerns and regulations like the General Data Protection Regulation, GDPR, and the California Consumer Privacy Act, CCPA, it really shows how fundamental these ideas are, regardless of the technology.
Absolutely. They laid the groundwork for so many of our modern privacy laws and regulations. It really raises an important question for us today, doesn't it? How do we ensure these timeless principles are integrated into rapidly evolving technologies like artificial intelligence, big data analytics, where information is processed and shared at speeds and in ways unimaginable back in 1973? It's a continuous, complex challenge for all of us. 10. Summary recap.
Wow, what an incredible deep dive. We've covered so much ground today, from the intricate nuances of digital investigations all the way to the ethical fabric that really holds our entire profession together.
My head is swimming with crucial takeaways.
It's definitely a lot to process, but each piece is truly critical for anyone working in this field. Let's quickly recap some of the essential nuggets for you. Okay, sounds good. We started by understanding that investigations aren't just one size fits all, right? There's a whole spectrum involved.
Correct. We learned about the various investigation types: administrative, operational, criminal, civil, regulatory, and those based on industry standards like the Payment Card Industry Data Security Standard, PCI DSS. Each has different purposes, different burdens of proof, from the extremely high, beyond a reasonable doubt, down to the preponderance of the evidence and specific evidence collection standards you have to follow.
And when it comes to all that electronic information, the Electronic Discovery Reference Model, the EDRM, is essentially our roadmap for handling it systematically.
Yes, the EDRM guides the 9 key aspects of e-discovery, from information governance right at the start, all the way through to presentation in court. It ensures a systematic and, importantly, legally sound approach to handling digital data for legal cases. It's that methodical journey.
Then we moved into the core of evidence itself, what actually makes information admissible in court. It's not just anything.
Right. Evidence must be relevant, material, and competent. We explored real evidence, the physical objects like a hard drive; documentary evidence, things like logs and emails; testimonial evidence, witness accounts, expert opinions, remembering the hearsay rule and its crucial business records exception; and demonstrative evidence, those diagrams that help explain things. We also highlighted the best evidence rule and the parole evidence rule for documents.
And to protect all that evidence, make sure it's not tampered with, the chain of custody is absolutely key. That unbroken chain.
Absolutely crucial. The chain of custody, or chain of evidence, meticulously documents everyone who handles evidence, from the moment it's collected right up until it's presented in court. It ensures its integrity and prevents claims of tampering by recording every movement, every handler.
We then broke down the actual forensic procedures for collecting these digital artifacts, those golden rules.
We discussed the 5 International Organization on Computer Evidence, IOCE, principles that guide technicians, and the specific forensic techniques: media analysis using write blockers and cryptographic hashes for integrity; in-memory analysis with memory dumps for that volatile data in RAM; network analysis using span ports and packet captures to reconstruct traffic; software analysis leveraging the National Software Reference Library, NSRL, for authenticating files; and hardware and embedded device analysis for all those specialized systems.
And that core idea that every contact leaves a trace, that Locard's exchange principle working in the digital world, right? Connecting all the dots.
Exactly. Even something like a structured query language, SQL, injection attack, leaves traces on multiple systems: the attacker's device, network devices, the web server, the database server, all providing crucial evidence to piece together the full story.
The investigation process itself had some critical steps we covered, especially around legally gathering evidence and deciding whether to involve law enforcement.
Indeed. We covered everything from forming a competent team with a clear charter to the legal nuances of gathering evidence ardaches, voluntary surrender, subpoenas, the plain view doctrine, search warrants based on probable cause, and exigent circumstances. We also stressed the importance of not hacking back and the critical difference between professional interviewing versus interrogation.
Yeah.
And protecting data integrity through remote logging and digital signatures is vital too.
And then we explored the darker side, the major categories of computer crime, really digging into the motives.
Right. We covered military and intelligence attacks, often using advanced persistent threats, APTs; business attacks like corporate espionage and ransomware; financial attacks involving cybercrime for hire and distributed denial of service; DDoS, terrorist attacks aimed at critical infrastructure; grudge attacks, often the insider threat; thrill attacks by script kiddies doing website defacements, and hacktivist attacks using methods like denial of service, DOS. Understanding the attacker's motive really is critical for effective defense.
Finally, we grounded ourselves back in ethics, the moral compass.
We discussed the importance of organizational codes of ethics and, critically, the ISC Code of Professional Ethics with its preamble and 4 canons. Protect society, act honorably, provide diligent service, and advance the profession. We touched on Request for Comments 1087, RFC 1087 for Internet ethics, the 10 Commandments of Computer Ethics, and that foundational code of fair information practices for handling personal data principles that still underpin modern privacy laws like GDPR and CCPA.
What an incredible journey through investigations and ethics. You are now truly equipped, I think, with a deeper understanding of these vital areas.
You certainly are. There's a lot there, but it all fits together.
And that wraps up another illuminating deep dive into the complex world of cybersecurity. We truly hope this exploration has given you not just facts and definitions, but maybe a robust framework for critical thinking about the profound responsibilities that come with navigating our increasingly complex digital landscape.
Indeed. And maybe consider this provocative thought as you move forward. In an era where artificial intelligence can both automate sophisticated attacks and streamline investigations, how will our existing ethical frameworks need to adapt? How do we ensure accountability and maintain public trust when the human element becomes increasingly abstracted from the direct action? It's a question worth pondering deeply as you continue your journey in this field.
A truly fascinating, maybe slightly scary thought to leave us with. Thank you for joining us for this deep dive. Until next time, keep listening, keep learning, and stay curious.